The Verdict, a Sidebar production, hosted by Kent Myers and Mick Cornett. As a part of its traditional and continuing commitment to public and community service, Crow & Dunlevy sponsors The Verdict. Also sponsored by Delta Dental, Oklahoma Lawyers for Children, and C.H. Guernsey & Company. Each week on The Verdict, we present an objective discussion of contemporary and legal issues, topical issues that will affect Oklahomans in their daily lives. The Verdict, a Sidebar production.
And welcome once again to The Verdict. I'm Mick Cornett, and I am joined as always by one of Oklahoma's top legal experts, Kent Myers. And Kent, today another guest.
Another guest, and before we get to that, what does the number 99 mean to you?
Wayne Gretzky.
Oh, well, it means 99 shows for The Verdict.
Well, that too.
I wouldn't have thought of Wayne Gretzky, but who would have thought we'd have made 99 shows also?
Yeah, both remarkable.
That is, yeah, I think our record is just as remarkable as his in longevity. In any event, we're pleased to be doing show 99 today, and we're having a battle of sorts. It's a battle of 2003, the doctors versus the lawyers. One can say, what else is new? But we see in the paper, in the press, in the legislature, discussions that medical malpractice insurance premiums that doctors have to pay are getting so high that doctors are shutting down practices, leaving the state because they can't afford to pay them. The doctors and the medical association say it's because the jury verdicts that the trial lawyers are getting are so high and so out of touch with reality that it's causing the premiums to go up. Others would say, the lawyers might say, it's because the insurance companies are overcharging people who can afford to pay premiums, the doctors. But that's generally the subject we're going to have today. Now, we had hoped to have two guests today, but we're only going to have one for this show. We had hoped to have Jim Loftis, the president of the Oklahoma Trial Lawyers Association, and we will have Jim today. We'd also hoped to have Dr. Jack Beller, the incoming president of the Medical Association. Dr. Beller's schedule would not permit him to be here with us, but he has agreed to come on March 23rd and kind of present our second show with just Dr. Beller. So we're going to have the subject, but it's going to be split into two parts.
Okay, well, we'll get started. Jim Loftis, our guest today, will be right back. You're watching The Verdict.
The Journal Record is
Welcome back to The Verdict. Mick Cornett with Kent Myers, who's going to introduce our guest.
We are very pleased today to have the president of the Oklahoma Trial Lawyers Association, Jim Loftis, with us. Jim is a Southeastern Oklahoma State University graduate for his undergraduate degree. He got his law degree from the University of Oklahoma, and he teaches as an adjunct professor at the University of Oklahoma in the area of civil pretrial litigation. He's a practicing lawyer in Norman, and his practice focuses principally on medical negligence, malpractice, hospital negligence, etc., and other areas. Jim, thank you for joining us today. We really appreciate you appearing on The Verdict.
Kent, thank you for inviting me.
We're glad to have you. Let me ask you, Jim, we see written in the press and on sound bites that medical malpractice judgments against doctors are so large as to not be based on anything bordering on reality. Is that your experience in this area?
The short answer to that is no, Kent. That's not my experience. I, too, have seen those comments in the paper and in the media. My experience has been that Oklahomans are a conservative group of people, and they're a fair-minded group of folks that will listen to both sides of the story. And if, in fact, there are, we've heard the term runaway juries, I think is one that's been bandied about by the insurance industry and the physicians. There is a three-tier protection already in place in Oklahoma if, in fact, we could ever find one of those runaway juries, which to this point, if they've run away, they've run so far away that the doctors in the insurance industry can't seem to find even the names of one of them. But we have a three-tiered protection, and it starts with the trial judge. If, in fact, the evidence in a case is insufficient to support an award of damages for a victim, the trial judge has the authority to set aside any verdict or to grant judgment and not even let the case get to a jury. We have two other tiers of protection, the Court of Appeals and our Supreme Court, who also have a similar authority if in fact the case is not supported by evidence. Likewise, if the argument is that the jurors are being influenced by passion or prejudice, the trial judge and the appellate judges have the same authority there to order a remediator if they believe that the verdict is out of line with what the evidence was that was presented to the jury. So there are already protections in place, and I have heard of no specific case where the physicians have pointed to a particular case and said, look at the verdict in this case, it was unfair to the victim. They got too much, the compensation for that victim was way out of whack with what the evidence was.
Well, let's bring up a graphic of a quote that was recently in the Daily Oklahoman. Dr. Beller, who has kindly consented to come on one of our later shows, was quoted as saying that the size of jury awards, and he was talking about medical malpractice awards, have gone through the roof. Thank you for the graphic. What's been your experience in that regard?
Well,
and the experience of the members of your association?
Again, this alleged crisis, which I believe to be a non-existent crisis based on the facts that I've seen, doesn't support the fact that any judgments have gone through the roof, so to speak. There may, in some circumstances, have been an increase in some jury awards. I don't believe that anyone can point and say that's attributable to the pain and suffering cap that the doctors and the insurance industry seek to impose through this legislation. The simple fact is, we all know it, we've seen it in our own bills. Hospitals' charges have gone up, doctors' charges have gone up, the cost for prescription drugs has increased, and you can't attribute that to medical malpractice premiums because the studies have indicated that medical malpractice premiums make up approximately 0.5% of all healthcare costs in America. So again, until somebody can hold up a verdict or a judgment and show me this one's through the roof, I think that's empty rhetoric.
So you would say the malpractice judgments are not ascending, or that they're ascending because of outside factors that are outside of the attorney's control?
What I'm saying, Mick, is that in some situations you may find that some malpractice verdicts, and there are very few malpractice verdicts, by the way, that these cases are seldom tried, and they make up less than 1% of all litigation in America is tied to malpractice claims. But when you do see a larger verdict, you can probably look if you knew the facts of that case, you could probably look and see, well, the victim is going to have future medical care, and that future medical care includes additional surgeries, physician fees, hospitalizations, the cost of medication, and those are the items that we have seen increase dramatically, and you can't equate that to a malpractice premium crisis because, again, only 0.5% of all healthcare dollars are attributable to malpractice premiums.
Well, let me ask you this. There's been some discussion of some new legislation, and we'll touch on it now and come back to it in a few minutes. But there's been some new legislation introduced in the legislature, which I understand is now kind of on hold. One aspect of which would be to put a cap, just like you mentioned, on the amount any particular plaintiff could be awarded in what the legislation calls non-economic damages. I presume that means pain and suffering and the like. What's your view about putting any statutory limitation on pain and suffering damages?
Well, I don't understand why our legislature would want to consider to limit the constitutional rights of 3.5 million Oklahomans to have a jury of their friends and neighbors, who, by the way, are the friends and neighbors of the doctor as well, decide what is fair. If you put a cap of $250,000 on pain and suffering, it's going to result in discrimination against the groups of people that can least afford discrimination: children, stay-at-home parents, and the elderly. And what it will do, Kent, is it will give the insurance companies absolutely no incentive to resolve even the most meritorious of those cases, because what's the worst that can happen? $250,000 judgment and even a good case can be lost. So it will effectively shut out a significant portion of the Oklahomans who don't have high economic earnings from ever having access to the courthouse for any negligence that they suffer at the hands of physicians or other healthcare providers.
Well, let me follow up on that just a little bit and see if what I'm hearing makes sense. Are you suggesting that, well, first of all, the vast majority of medical malpractice claims or cases are settled?
Well, I don't have the facts and figures on settlement versus trial. I can tell you that medical malpractice claims make up a very minute portion of all litigation that is filed either in Oklahoma or nationwide. And I can tell you that the information that I've seen in the last 4 or 5 years in Oklahoma County, our most populous county, there were literally 25 or maybe 30 cases that went to a jury verdict.
So that suggests that many of them are being settled.
That suggests that a fair portion of them are being settled.
Let me jump in and get us to our first break. We're visiting with Jim Loftis, the president of the Oklahoma Trial Lawyers Association. You're watching The Verdict, and we'll be right back.
One 888-412-BIGGS.
Mick Cornett and Kent Myers back on The Verdict. We're talking to the president of the Oklahoma Trial Lawyers Association, Jim Loftis. Kent, where now?
Well, Jim, when we broke, we were just touching a subject I want to follow up on and see if I understand correctly. The proposed legislation does, among other things, propose to cap non-economic or pain and suffering damages at $250,000 per case. Could that create a disincentive on the part of the defendant doctor to settle because that number is now limited, and have the result be that more cases go to trial now than are presently going to trial, and that put a strain further on the jury system?
Well, Kent, that's certainly a scenario that could play out. There are two possible scenarios that I see, and both of them are bad for the citizens of Oklahoma. There is certainly going to be a disincentive to settle a meritorious case whenever you know that it's an injury to or the death of a small child, the death of a stay-at-home parent, or maybe the injury to an elderly individual, because the bulk of their damages are going to be in the nature of pain and suffering in the event of a death case. And the insurance companies can then say, we have put a value on human life of $250,000. So what's the risk? On the most meritorious case, let's go try it, because even a good case can be lost, and let's see if we win, because we know that our risk is only $250,000. The other way I see that playing out is because of the expense of a medical negligence case. You're looking at spending $30, $40, maybe up to $100,000, depending on the case, to get it to trial. Is if you limit pain and suffering to $250,000, you are effectively closing the door to those groups of individuals we've discussed, the elderly, the stay-at-home parents, and children who don't have the economic earnings, because how can you look at spending that kind of money to prosecute a case when you know that it could only, in the best case scenario, end up with a $250,000 award? Mm-hmm. And, you know, more importantly, the juries, in my understanding of the legislation, is the juries would not even be informed of the fact that there was a $250,000 cap. So I don't think it's fair whenever we have legislation coming forward that says, let's take away the rights of our neighbors and our friends to decide what's fair.
And keep it secret.
And keep it secret. We have in this state adhered to the principle that our neighbors and our friends have the common sense to determine whether to make life and death decisions in a criminal case, to make decisions in any other case not involving a physician. I mean, does it hurt less if the injury is caused by a physician as opposed to you or I being negligent and causing some injury? So the bottom line is a $250,000 cap is not fair, and it's not right to ask Oklahomans to give up their constitutionally protected rights in order to pad the pockets of the insurance companies. Because what we have seen across the nation is that caps simply do not work if the goal is to reduce medical malpractice premiums. Oklahoma enjoys the lowest medical malpractice premiums in the entire country, and we don't have caps.
Well, give me an idea that if we're the lowest, what's a typical premium? See, I don't have any idea what a doctor would be paying, and I'm sure it varies depending on their medicine and their history of legal problems. But what would be typical for a physician?
Well, I think in Oklahoma, the last numbers that I saw across the board, of course, specialties, a general practitioner will certainly pay less than maybe a thoracic surgeon. But generally, I believe that the average premium in Oklahoma, the last data that I saw, was approximately $10,000.
A year?
A year. Okay. But irrespective of that, you can look on PLICO, the Physician Liability Insurance Company's website, and they will tell you, even with the increases that they're seeing this year, and we can talk about the reasons for those in a moment, but even with those increases, they still have the lowest medical malpractice premiums in the entire country. Doctors are not fleeing Oklahoma. Oklahomans are not having a problem of access to health care. In fact, the data shows that in states that do not have caps, like Oklahoma, there is approximately 4% per capita more physicians to treat patients than in states that do have caps.
Well, let's talk about the reasons that you alluded to. What are the reasons that these judgments are getting larger, or if they are?
Well, if in fact there are some judgments that have been larger, I think, as we discussed earlier, that can be attributed to the increased cost of hospitals, the fees they charge, the increased cost of physicians' fees, the increased cost of drugs. And I think the Kaiser Family Foundation did a study on that and determined that, I don't recall the time frame, but there was a 67% increase in the cost of prescription drugs, a 50-something% increase in the cost of hospitalization, a 44% increase in the cost of physicians' fees, and on down the line. And medical malpractice premiums and medical malpractice judgments didn't even make the list on the Kaiser Family Foundation study as to what is driving up the cost of health care. So again, the cost of health care and the litigation involving medical negligence are wholly unrelated. If you look at what has been said by the American Insurance Association, they will tell you that they cannot promise physicians that enacting tort reform, capping damages at $250,000, will ever lower physicians' premiums, because the truth of the matter is they are totally unrelated. And I'll be happy to go into that if you would like.
Well, let me ask you this. Let's call up a graphic real quickly, and we're going to have to kind of scoot it right along. Another quote, "Far from being the protectors of patients from incompetent physicians, attorneys actually are the benefactors by keeping over 50% of jury awards in medical liability cases." Just real briefly, Jim, before you have a chance to sum up, tell us what you think about that. Are lawyers keeping over 50% of the jury awards?
That is absolutely untrue. Statutorily, lawyers are prohibited from doing anything of that nature, and any lawyer that did that, we would be reading about them being disbarred. I don't know who is providing that information to Dr. Beller, but it is an absolute untruth.
Jim, I'd like to give you a chance to sum up your views on this subject. We've covered a lot of areas today. 30, 45 seconds to address the camera if you'd like and tell us your thoughts.
In Oklahoma, there is no medical malpractice crisis. This has been a nationwide effort, and it has been brought to Oklahoma. Our physicians in Oklahoma enjoy the lowest premiums in the entire country. They're not leaving the state. We hear that story. Physicians are leaving the practice, but we don't ever hear where they're going. Oklahomans have access to health care. There is no danger that they will not have access to health care. Physicians, even with the increase in premiums, which we've all seen, my homeowner's insurance went up 30% this year. It is all tied to the investments that the insurance companies have made in the market, and that includes Plico, who will tell you that they're not involved in the market because they buy bonds. But the fact of the matter is, 3 years ago, you could get bonds for 9%. Now those bonds are paying maybe 4.5%. The market that the reinsurers invest in, which is where Plico passes on most of its risk to these large multinational insurance companies, they have lost money in the markets, and now they are turning to the physicians, just like they turn to you and I on our homeowners policies, to increase premiums to make up for the losses that they've sustained in this tough market times.
Jim Loftis, President of the Oklahoma Trial Lawyers Association, thanks for joining us on The Verdict.
Thank you.
Thank you, Jim.
Kent and I'll be back with a final word after this. We're back to wrap up another edition of The Verdict.
The tort reform battle has started again. One side says we've got a system that's out of control, it needs reforming. The other side says not so. There may be other reasons for causing some awards to be up where they are today. It's an interesting discussion, interesting questions being raised. We really appreciate Jim Loftis being with us today, and Dr. Beller, Jack Beller, the president-elect of the Oklahoma Medical Association, agreeing to come on March 23rd and discuss the rest of the story, if we can phrase it that way. What's the cause of medical malpractice insurance premiums going up? Is it the cost of the jury verdicts? Is it the cost of the insurance companies thinking they can make up losses elsewhere by raising those kinds of premiums? We'll see.
It'll be interesting to hear that other side of the story.
It will.
Well, that's going to do it for today. Thanks again to our guest, Jim Loftis. And we also know a couple of friends of The Verdict have been feeling under the weather lately. I want to wish a speedy recovery to both Pam Myers and Larry Blankenship. We'll see you next week on The Verdict.